Before we begin, we'd like to give special thanks to all of our sponsors for helping make this event possible each year. Specifically, thank you to CRL FormFox for being our title sponsor for 5 consecutive years. And thank you to our platinum sponsors, OraSure Technologies, Psychmedics, Samba Safety, UKG, and Quest Diagnostics. Hello, and thank you so much for joining us for another session. This session is on creating a compliant adverse action process from start to finish. Today, we're joined by Eden Hutchinson, Compliance Investigation Manager at DISA Global Solutions. Eden, how are you doing?
Hi, Thomas. I'm doing great. Thank you.
Awesome. Well, thanks for being here. Before we jump into the presentation, I do want to remind everyone that if you have any questions, use the Q&A button at the bottom right of the player, and any questions we're unable to answer today, we'll reach back out to you after Day with DISA. Additionally, we will be making a copy of this presentation available for download in the Materials tab after the session. With that being said, Eden, the floor is yours.
All right, so my name is Eden Hutchinson, and as Thomas said, I'm the Compliance Investigation Manager here for DISA Global Solutions. I've been with DISA for just over a year, so this is my very first time participating in Day with DISA. I've been in the background screening industry for approximately 11 years. Right now, I oversee the background screening compliance team, and we ensure that DISA maintains compliance with the Fair Credit Reporting Act and all other laws and regulations applicable to consumer reporting agencies and background screening. So I'm going to start off first with standard disclaimer to let you know that this session is intended for educational purposes only. It is not to be construed as legal advice in any way, shape, or form. And as always, DISA highly recommends that all of our clients consult with legal counsel in all your employment screening matters to ensure proper compliance with law and regulation. The information in this session is based, of course, on the law, and then also based on best practice guidance established over the years by industry leaders. All right. So there are tons of laws and regulations that apply to employers in the United States. It can be really difficult often to navigate those laws and ensure proper compliance. So today, we're going to be talking about one set of those laws and regulations that impact employers and their interactions with employees and job applicants, and that is adverse action. So I'm sure that you all are familiar in some way with adverse action. But today, we're going to take a pretty deep dive. Adverse action remains one of the top areas of litigation for U.S. employers. So it's really important that you guys have a solid understanding of the federal, state, and even local laws that dictate how you take adverse action. So first, what is adverse action? Well, according to the Equal Credit Opportunity Act, or the ECOA, adverse action means a denial or revocation of credit, a change in the terms of an existing credit arrangement, or a refusal to grant in substantially the amount or on substantially the terms requested. Now, the Fair Credit Reporting Act, the FCRA, which is the regulation that dictates how consumer reports are handled, we're going to be talking about that a lot today. The FCRA goes further and expands the definition to mean a denial or cancellation of any insurance existing or applied for in connection with the underwriting of insurance, a denial of employment or any other decision for employment purposes that adversely affects the current or prospective employee, a denial or cancellation of any license or benefit described in Section 604 of the FCRA, an action taken or determination that is made in connection with an application that was made by or a transaction that was initiated by any consumer and adverse to the interests of the consumer. So not only does the FCRA regulate adverse action, but there are also a multitude of state and local laws, sometimes referred to as ban-the-box laws or fair chance laws, that may also apply depending on the location of the employer, the location of the job itself, or the location of the applicant or employee. and then also whether the employer is public or private. So for our purposes today, we're going to be discussing adverse action just in connection with employment purposes. Okay, so we're going to start with the federal law, the FCRA. According to the FCRA, adverse action and the requirements surrounding adverse action only apply if that negative decision is made based on the results of a consumer report. So for example, if you order a consumer report on someone and then decide to take an adverse action against them due to a criminal record that appeared on the report, then that would be adverse action under the FCRA and the regulation would apply. Now, if you decide not to move forward with somebody because of something that has nothing to do with the consumer report at all, then that would not be considered adverse action under the FCRA and the requirements would not apply. So I keep saying consumer report, and of course that's the background check. But in order for it to be a consumer report under the FCRA, it must be created by a consumer reporting agency, a CRA, like DISA. It must also have a bearing on the consumer's creditworthiness, credit standing, credit capacity, character, general reputation, personal characteristics, or mode of living, and it must be ordered and used for a permissible purpose, such as for employment purposes. We're also going to be using the term consumer a lot today, and what that means is your applicant or your employee. Okay, so the FCRA has two specific sections that address adverse action. The first one is section 604B3, and that one applies only to those who have ordered the consumer report for employment purposes. Section 615, we're going to go over that one a little bit later. All right, so adverse action for employment purposes. What is that? Well, obviously, it means deciding not to hire a candidate based on the results of the consumer report. But that's not the only scenario. So this could also mean deciding to fire an existing employee, deciding to demote or not promote an employee. It could also mean reducing an employee's responsibilities, like their driving responsibilities, suspending an employee, anything that can be seen as a negative action in regard to the individual's employment based on the results of the consumer report. Okay, section 604B3 also states that prior to taking adverse action based in whole or in part on the information contained within the consumer report, the employer must provide the consumer with a copy of the report in question, as well as a copy of the Consumer Financial Protection Bureau, the CFPB's, a summary of your rights under the Fair Credit Reporting Act. This is generally known as the pre-adverse action process. And it's really important to stress that this is done before any adverse action is taken, before any final decisions are made. The whole purpose of this step is to allow the consumer time to review their report, to make sure that there are no inaccuracies, and if there are any inaccuracies, to get those cleared up. This step is also important because it allows the employer to discuss any possible records with the consumer and perform any additional steps that may be required applicable to state or local laws, such as performing an individualized assessment. So as part of this pre-adverse action process, employers typically send a notice called a pre-adverse action letter, along with a copy of the report and a summary of rights. And while sending this particular notice is not technically a requirement of the FCRA, it has become a really standard step based on years and years of best practice guidance and industry standards. There are also certain states like California that require that this pre-adverse action letter be sent. There may be a couple more as well. Okay. The next section, section 615 of the FCRA, it's a broader requirement for adverse action, and it applies generally. So it does not just apply to those who order the consumer report for employment purposes. This section states that when taking adverse action based in whole or in part on the information contained within a consumer report, I'm going to say that so many times today. So basically at the exact time that that action is being taken, a notice of adverse action must be sent to the consumer either orally, in writing, or by electronic means like email. This notice must include the name, address, and telephone number of the CRA that furnished the report, and a statement that the CRA did not make the decision to take adverse action and is unable to provide the consumer the specific reasons why the adverse action was taken. That's a really, really important part. The letter must also include a notice of the consumer's right to obtain a free copy of the report from the CRA within 60 days of receiving this notice, and the right to dispute with the CRA the accuracy or completeness of any information within the consumer report. Now, generally, this notice is referred to as the adverse action letter, or sometimes the final adverse action letter. And yes, some of the information is redundant between this section and section 604. So for example, section 604 requires that you give a copy of the report, but 615 says that they need to be notified of the right to request and receive a copy of the report. 604 requires the employer send a copy of a summary of your rights, which outlines the consumer's right to file a dispute. And then 615 again, says that they have to be provided a notice of their rights to file a dispute. So you may be thinking, can't I just follow 604 or 615? Why do I need to do both of these? They're, a lot of them have the same requirements. Well, unfortunately, the Federal Trade Commission, the FTC, who is a regulator of the FCRA, has issued opinions in the past that employers taking adverse action must still comply with both sections despite all of the redundancies. It just makes it safe for everybody. All right, so now we're going to take a look at what these pre and adverse actions letters may look like. Note that they're just sample forms only. There are no model forms for these at the moment, though some may be coming soon, someday, fingers crossed. Let's see. Okay, so first, before we get into it, it's really, really important for me to note that adverse action is strictly an end user employer requirement. This means that following all the requirements, sending the notices, the copies of reports, as well as any additional state or local requirements that come into play, ultimately falls to the employer. So even in cases where a CRA provides adverse action services on behalf of their clients, the onus to use the proper forms and to meet all legal requirements remains on the employer. So this is why DISA strongly advocates for our clients to always consult with their legal counsel in all employment screening matters, especially prior to utilizing any legally required forms. Okay, so thankfully, employment adverse action forms, they're pretty standard. So aside from any notices or attachments that may be required at the state or local level, if you've seen one, you've seen them all. So you may be able to obtain some sample forms from the SHRM website. That's the Society for Human Resources Management. It's an excellent resource for employers. Or you could obtain them from your CRA. DISA, we have our own sample adverse action forms that we offer up to our clients to adapt or adopt or not as you see fit. Of course, with prior review and approval from your legal counsel. Okay, so the pre-adverse action notice will make it clear that it's a pre-adverse action letter. It will state that the company, you, may take adverse action or is considering taking adverse action based in whole or in part on the information contained within the consumer report. Let's see. Some states and localities, they may also require that you list the specific items in the consumer report that were the basis for the preliminary decision. So you can add those to this form here as well. The letter also mentions any enclosures, which again are the exact copy of the report in question, along of course with the contact information for the CRA who provided the report. A summary of your rights, and any additional state or local documents or notices you're required to send, such as a copy of New York Article 23A or the written assessment that's required in Los Angeles. So next, the letter generally outlines the consumer's rights to dispute the accuracy or completeness of the report. And if the report is complete and correct, but the consumer wishes to provide additional information or documentation that's going to better assist your team with making that final determination, they really should be given the opportunity to do so. So you should provide contact information for someone within your company not your CRA, because again, CRA does not make the hiring decision, so that the consumer can discuss any of those extenuating circumstances with somebody on your team. Okay, and then finally, the letter is going to include the number of days, generally business days, that you are going to wait before moving forward with that adverse action. Now, the FCRA doesn't actually have a standard set time, but 5 to 7 days generally is an accepted standard. There may be other states or local laws that dictate a different waiting period, such as Philadelphia, for example. They require a 10-day waiting period. So really important to review your documents fully with your legal counsel. Okay, so the adverse action notice is very similar to the pre-adverse action letter, except it will state that adverse action is being taken. For example, it could say, we have decided not to offer you employment, or decided not to give you the promotion, or we have decided to terminate your employment based, stay with me, in whole or in part on the information contained within the consumer report. That might be the last time I say this today. You may also, again, list the specific items for the reason for the denial here within the form. And then because you've already given a copy of the consumer report, here is where you can document that one was previously provided, and then also state that they have the right to receive an additional copy within 60 days of receiving this notice. Here you can also clarify that the CRA did not make the employment decision and cannot provide the specific reasons as to why that decision was made. The letter will then, end with any state or local notices that may be required, depending on job, employer, or candidate location, and then include, any specific attachments that need to be sent as well. So some employers may opt to take additional steps as part of their standard adverse action process. So for example, implementing a policy that requires a certain level of review of criminal records prior to making a determination to take adverse action. The Equal Employment Opportunity Commission, the EEOC, issued guidance in 2012 on the consideration of arrest and conviction records and employment decisions under Title VII of the Civil Rights Act. And while this guidance is just that, it's guidance, it's not a law or a legal requirement, it has become highly regarded as the utmost best practice to ensure that these decisions are made for the right reasons and that your company does not engage intentionally or unintentionally in employment discrimination. It's recommended that each specific criminal record be reviewed to determine how it applies to the job in question and whether it's consistent with business necessity. So this guidance advocates for the review of what the EEOC dubs the green factors. The green factors are the nature and gravity of the offense or conduct, the time that has passed since the offense, conduct, and or completion of the sentence, and the nature of the job held or sought. So careful consideration of these particular factors can help employers determine whether a specific crime may be relevant to concerns about risks in a particular position, and to help prevent a type of employment discrimination called disparate impact discrimination. So disparate impact discrimination can occur when an employer's neutral policy or practice has the effect of disproportionately screening out a Title VII protected group, and the employer fails to demonstrate that the policy or practice is job-related and consistent with business necessity. So some employers may think that having a blanket disqualification policy, for example, not hiring anyone with this or that type of criminal record, is actually more fair and less likely to see them in hot water. But the truth is actually the opposite. So the Supreme Court once referred to these types of policies as fair in form, but discriminatory in operation. So nationally, African Americans and Hispanics are arrested and incarcerated in numbers disproportionate to their representation in the general population, which means that policies that automatically exclude employees or candidates with criminal records will in turn disproportionately exclude African American and Hispanic employees and candidates, creating instances of disparate impact discrimination. So review and consider those green factors, and it will really help reduce your risk. I really recommend that all employers read this guidance from the EEOC, either when creating your employment screening policies or reviewing and updating them. So as I've mentioned throughout the presentation, some states, cities, and even counties have laws and regulations in place that add even more requirements to an employer's adverse action process. So some of these laws, referred to as ban-the-box laws or fair chance laws, apply to public employers, shown here in this graphic by NELP in blue, some to private in yellow, and then some to both public and private employers. Now, the orange states in this graphic indicate states that have no state law, but might have city or county level laws. For our purposes today, we're going to discuss the laws that specifically apply to employers in the private sector. So in July of 1998, Hawaii was the first U.S. state to implement a statewide law of this nature. It's Hawaii Revised Statute 378-2.5 for those who care about that. And it states that adverse action may only be taken if the prospective employee has a conviction record that bears a rational relationship to the duties and responsibilities of the position in question. It also dictates the timing of an inquiry into criminal history, stating that a conditional offer of employment has to be made prior to requesting a criminal record check. So many of the states and counties with these types of laws have requirements or prohibitions of a similar nature to that of Hawaii. Currently, there are 16 states and 23 cities and counties with laws that impact a private employer's adverse action policy. These laws could prohibit an employer from asking an applicant to disclose criminal records on an application or otherwise. So that's the actual banning of the box. Could dictate the timing of a criminal record inquiry, the types of records that may be considered, whether an individualized assessment, such as consideration of the EEOC's green factors is required, and then whether additional notices need to be provided, even how long the employer must wait between sending that pre-adverse action notice and then taking adverse action. So obviously we're not going to go over all of these statewide and county laws today, but we're going to touch on just a couple to give you an idea of some of the issues that you will need to keep an eye out for. So California and New York are two states known for having fairly strict fair chance laws with multiple requirements. California has a statewide law which applies to employers within the state with 5 or more employees. Under the law, employers may not include any questions on the application or inquire in any way prior to making that conditional offer of employment whether the applicant has any convictions. The employer may not consider arrest-only records that are not currently pending. They may not consider referrals to or participation in pretrial or post-trial diversion programs or convictions that have been sealed, dismissed, expunged, pardoned, or statutorily eradicated under the law. If an employer intends to deny an applicant employment based on conviction history, they must make an individualized assessment of whether the applicant's conviction history has a direct and adverse relationship with the specific duties of the job. So they need to consider the nature and gravity of the offense or conduct, the time that has passed since the offense or conduct and completion of the sentence, and the nature of the job held or sought. Sound familiar? Yes, those are almost word for word the exact same as the EEOC's green factors. So pre-adverse action letter for California, it needs to be sent, and it needs to outline the disqualifying conviction or convictions that were the basis for that preliminary decision. It also needs to include an explanation of the applicant's right to respond to the notice and provide any evidence that they wish of inaccuracy, of rehabilitation, or any other mitigating circumstances. If the applicant does respond to the letter in writing within 5 business days, then they will have an additional 5 business days to provide that evidence, and the employer must consider all of the documentation or information provided before making the final decision. If the final decision then is made to deny the applicant based on any conviction history, then the employer must send the final adverse action notice and include any existing procedure that they may have for the applicant to challenge the decision or request reconsideration. The notice must also include the applicant's right to file a formal complaint. Now, of course, there are exceptions for this and for other states that have fair chance laws. So, for example, some aspects of this particular law may not apply for any positions where an employer is required by any state, federal, or local law to conduct a criminal background check for employment purposes, or to restrict employment based on conviction history. So again, very important to check with your legal counsel to ensure your compliance and that you're not putting your company at any unnecessary risk. So not only does the statewide law apply in California, but certain cities within the state, Los Angeles, San Francisco, for example, they also have similar ban-the-box laws that may also apply. So just keep those in mind. Similarly to California, New York State has fairly strict fair chance laws as well. And some cities within New York, such as Buffalo, Rochester, and New York City, which has become quite a whopper, they have their own versions as well. So New York Article 23A is a law that prohibits both public and private employers having 10 or more employees, from unfairly discriminating against any applicant in the state of New York that has one or more convictions. So employers must review the conviction history to determine whether it has a direct relationship between one or more of the criminal convictions and the specific employment sought or held, or that granting the employment or keeping the individual employed in that position will involve unreasonable risk to property or to the safety or welfare of any specific individuals or the general public. So the factors that must be considered for the New York Article 23A are the public policy of the state, the specific duties and responsibilities necessarily related to the employment sought or held, the bearing, if any, the criminal offense for which the person was previously convicted will have on his fitness or ability to perform one or more such duties or responsibilities, the time which has elapsed since the occurrence of the criminal offense, the age of the person at the time of the occurrence, the seriousness of the offense, any information provided by the person or produced on their behalf in regard to their rehabilitation and good conduct, and then the legitimate interest of the public, the property, the welfare of any specific individuals. It's a lot more than the EEOC's green factors, to be sure. So then if the candidate or employee who is denied employment based on conviction history, if they request it, the employer must provide within 30 days a written statement setting forth the reasons for the denial. Okay, so now let's go over some of the real life examples of potential consequences of non-compliance, as well as some recent examples of employers who had to pay a pretty penny for not complying with the FCRA's adverse action laws. So first, non-compliance with the FCRA itself can not only result in loss of business, damage to company brand and reputation, it can also lead to some pretty severe monetary penalties. So negligent violations, perhaps an honest mistake, can result in actual damages plus reasonable attorney's fees. And then willful violations, where you really should have known better, they can result in actual or statutory damages of $100 to $1,000 per violation, plus punitive damages and reasonable attorney's fees. And then companies that choose to settle instead of fighting in court, they don't always fare much better. In 2019, a popular global coffeehouse chain that I will not name was involved in 2 separate class action lawsuits brought for failure to comply with adverse action requirements under the FCRA. The plaintiff in the first suit alleged that he was denied employment based on the background check that had multiple errors, and he was not provided the opportunity to correct those. He didn't get a copy of his report or a summary of rights until weeks after the adverse action was taken, and as a result, he lost the job and couldn't fight it in any way. The plaintiff of the second suit alleged that adverse action was taken without providing proper notice or a copy of the summary of rights. So these cases were merged into one, and the coffee giant settled the suits, providing benefits to approximately 8,000 former candidates, ranging from a $125 gift card to $840 in cash plus the gift card. All of that for 8,000 class members, that adds up for sure. A Florida dispensary recently settled a class action lawsuit for failure to follow the FCRA's adverse action requirements for $65,000 spread across approximately 1,000 class members. And a popular home improvement store was just recently hit with a class action in February of 2022 for failure to provide copies of the consumer report or a summary of rights. And then that one is still pending, so we'll have more on that soon. Now, these are only a very, very few recent examples of lawsuits involving employers and their failure to follow adverse action requirements. These are not all of them. In 2022 alone, over 5,000 consumers filed lawsuits under the FCRA. So what can you do now to protect yourself and ensure proper compliance with adverse action laws? Well, we've just entered into a brand new year, so now is the perfect time to review your current adverse action policies and related documents with your compliance team or your legal counsel. Ensure that you are providing the consumer with a proper disclosure required by the FCRA 604 prior to ordering the consumer report, which informs the consumer that a report may be obtained on them for employment purposes. And always be sure to obtain the consumer's written authorization to order the report. Understand the background screening laws, and employment laws relevant to your state and to your industry so that you can be aware of any required screens, required disqualifications, so you can reduce your risk and protect your business. Review your pre and adverse action forms and applicable attachments, and ensure that you are always including a copy of the report, a summary of your rights under the Fair Credit Reporting Act, and any and all state notices. Finally, ensure that you're waiting the required period of time between pre and adverse action notices. Okay, so that's it for me. If any of you are still awake after that riveting session, we can turn it over to questions.
Awesome. Thank you so much, Eden. So Eden, I know that we're tight on time. I know we only had you for 30 minutes and we're running up against it already. I'm just going to power through a couple quick questions, if that's all right, and try to get some of these. If we're unable to answer your specific question today, definitely expect someone to reach out within the next couple of days. We'll be taking all of the questions we're unable to answer live today. We'll get them in front of Eden, get her answers, and then have them communicated back out. Eden, the first question I have is, if the candidate files a dispute after receiving the pre-adverse action notice, do we have to wait until the dispute is complete before moving forward with taking adverse action?
Yes, great question. So yes, you absolutely should wait until the dispute is complete before you take the adverse action. The FCRA is a consumer protection statute, so it's there to protect the consumer. And they have the right to file a dispute, and they should also be given the right to wait for that dispute to be complete before you make the final decision. You also need to think about the fact that you don't want to miss out on an excellent candidate because of an inaccuracy. You want to get those handled, taken care of, so that you can make a correct decision.
Awesome. Are there any types of criminal records that DISA recommends always result in adverse action?
Yeah, so DISA, we're not the end user. We don't make hiring decisions for our clients, but the EEOC would say, no, there should not be any certain type or any certain level of criminal record that you should automatically disqualify a candidate. Each record should be reviewed, ideally, to make sure that it relates to the job in question, and hiring that person doesn't pose a significant risk.
Okay. If I receive a bad reference for a candidate and we decide not to hire the individual, do I still have to follow adverse action because it's not a criminal thing?
Yeah. So the information you received, it was part of the consumer report, and you're using it to make a decision on that person's employment. So the requirements of the FCRA would still apply. Criminal records are, of course, the most prevalent issue that causes adverse action, but they're not the only one. So anything that is inside the consumer report can be used to make an employment decision, and therefore you'd have to follow adverse action procedures.
Gotcha. Any recommendations on how to stay up to date on FCRA or other screening requirements?
Yes. So DISA, we have a lot of individuals who are FCRA certified through our PBSA, the Professional Background Screening Association accreditation, and we stay in constant communication with them to try to get information on any changes in laws and regulations, and periodically we'll send out, newsletters or blogs with updates. You can always call into client support and ask any questions that you may have as well, or reach out directly to background screening compliance through DISA, and we'll get you the information you need.
Okay. During COVID, we had to furlough employees. Is this covered by the suspension aspect of FCRA?
So no, because you suspended, you furloughed somebody because of COVID, and you didn't suspend somebody because of the results of the background check, then the FCRA would not apply in that case. So you wouldn't have to follow adverse action procedures.
Okay. If my employee lives in California but works in Nevada, whose laws do I use?
Well, generally, you want to apply the strictest of the, where the employer is located, where the applicant lives, and where the job is, just to be safe and to cover all your bases. Choose the most strict of all three of those locations.
Okay. And then can written authorizations be digital, or does it have to be ink?
Well, it really depends on the source that needs that authorization. So there's no requirement saying that it has to be pen to paper. As long as it is compliant with the e-sign act, it can be an electronic signature. But if a source requires an authorization, say you're doing an employment verification and they need a consent form before they proceed, if they require it to be written, then we may need to reach back out and request a handwritten signature. But no, there's no requirement that says that must be ink signature, pen on paper.
Awesome. Well, Eden, I know again we're tight on time, so I want to thank you for making time in your very busy day to be with us, and I appreciate you taking some time for Day with DISA.
No problem. Thank you so much for having me. This was tons of fun.
Awesome. Thank you everyone for attending this, and we hope to see you in our next several sessions. Bye-bye.